Hey everyone, and welcome to today's video. This time, we're looking at a courtroom scene featuring not one, but two sovereign citizens, both insisting they're living men, yet neither showing much understanding of what's actually happening around them. It's a short intro, but trust me, things get interesting fast. Let's jump right in and break it all down.
It looks like Mr. Azultine, I may be pronouncing that wrong, is had a fairly recent warrant. I would be if we're comfortable addressing that on the record.
Yep, Mr. Azultine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azultine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
This one is pretty straightforward. Jurisdiction is confirmed by basic facts, things like the date, time, and location. If you were in Thurston County at the moment you received your citation, then the Thurston County District Court does, without question, have authority over your case. And regarding your claim that the court failed to state a claim, that argument doesn't apply here. This isn't a civil lawsuit, so that defense doesn't work in this situation. It's important to understand the type of case you're dealing with before making those arguments, because using the wrong defenses only weakens your position.
And I have some questions before I feel comfortable with this court moving forward. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azultine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azultine, then you're a spectator and you're welcome to stay. If you are Ty Azultine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azultine?
Does the caption of this case not say Ty Warren Azultine in all capital letters?
Your Honor, I can speak with Mr. Azultine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
I see that he's refused counsel.
Yeah. If you're Ty Azultine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth, and if you look at the affidavit, it will clarify who it is that I am. There are two.
All right, I've muted your microphone. It appears to me that you don't claim to be Ty Azultine, so I'm going to strike Ty Azultine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
And just like that, he's gone. What makes this so surprising is that Thurston County, and Washington courts in general, are usually very patient with people who miss a court date. All he had to do was confirm his actual name, apologize for not appearing, and he would have been given a new date without much trouble. But instead, the warrant stays active, and now he's at risk of being picked up at any moment. It could happen while he's at work, running errands, or right in the middle of something important. That's the cost of not taking the court process seriously. Now, let's move on to our next sovereign citizen, someone I first saw featured on Colin's channel. The link will be in the description if you want to check it out later.
Calling case number 24 RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
You know, he could have saved everyone a lot of time by simply saying, "I'm Anthony Mathis, and I have no idea what I'm talking about." Instead, we got a long, confusing speech that didn't help his case at all. Moments like this really show how quickly things can go off track when someone refuses to give straightforward answers. It makes the whole situation harder than it ever needed to be.
Very well, Mr. Mathis. Today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color, on 11 Mile Road, near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options, and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very
So
well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
As the magistrate already explained, he isn't interested in debating your questions. What you're missing is that you requested this informal hearing, which means you're required to enter a plea to the civil infraction. That's how the process works. Saying you'll only plead to the Most High Snoop Dogg isn't a valid response in any courtroom. At this point, you need to follow the procedure you asked for, because refusing to do so only drags things out and makes your situation worse. The court is giving you a chance to handle this properly. You just have to take it.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
That's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay,
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
Right
terms
now.
of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak?
It's about 15 miles north of Detroit, and you should already know that. That's the exact spot where you went through the red light. This whole situation is a great reminder of why relying on the internet for legal advice can lead you in the wrong direction. Sovereign citizen arguments often mix up legal concepts from criminal cases or civil cases involving real harm to a person. In those kinds of cases, a defendant has a constitutional right to face their accuser. But running a red light isn't one of those situations. This isn't a case about personal injury or property damage. So the city doesn't need to bring physical evidence like pavement, signs, or anything else into the courtroom. Traffic violations are handled differently, and misunderstanding that only creates confusion and unnecessary trouble.
Please bring the
Court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay, well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code of the city of Royal Oak as it is adopted.
As I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward. As far as the injured party, no one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case under the Motor Vehicle Code, as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party,
Very well.
I honestly don't know why some people can't understand this. Refusing to present a defense is not a valid defense. It doesn't help your case. It actually guarantees the opposite outcome. Going into court with no argument, no explanation, and no effort is basically choosing to be found guilty. Courts need something to work with, and giving them nothing is the fastest way to lose.
You guys are.
Officer Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that, sir, is $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the Chief Judge of the District, and at that time, the City of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
All right.
I really appreciate judges who handle cases like this. They keep the hearing short, end it right away, and don't give the person any extra time to add more unnecessary comments to the record. It keeps everything clear, controlled, and moving forward. Now, for anyone wondering what happens next, he's left with two choices, and both cost him the same amount out of his own pocket. He can pay the fine and close the case, or he can pay the bond, which is equal to the fine, and request a formal hearing with the prosecutor. Either way, the city will still collect what it's owed, and he'll still have to take responsibility for what happened. In the end, it's a simple and fair outcome. All right, that brings us to the end of the video. Thanks so much for watching all the way through. If you enjoyed it, hit that like button. If not, feel free to tap dislike. And don't forget to leave a comment below and subscribe with notifications turned on so you never miss any of my upcoming content.